Criminal liability of organizations in occupational health and safety. It all started in a mine in Plymouth, Nova Scotia, when an explosion killed 26 workers at around 5:20 a.m. on May 9, 1992. Just before the tragedy, sparks generated by machinery caused a pocket of methane gas to ignite, where there were large amounts of coal dust on the ground. The two conditions combined to create a massive methane explosion which, sadly, killed 26 workers. This disaster shocked the entire country. The families of the victims were devastated, searching for answers and demanding justice. How could such a tragedy happen? An investigation later revealed that the methane detectors had been deliberately switched off. Safety had been sacrificed in the name of productivity. The public, outraged by the lack of due diligence on the part of the employer, tried to push through legislative reforms to hold companies responsible for such tragedies. Despite the seriousness of the situation, the mine officers escaped prosecution, because Canadian laws, at the time, did not allow companies to be adequately punished for workplace safety negligence. This event marked the beginning of a major shift regarding employer criminal liability in Canada. In 2002, after a decade of sustained pressure, the efforts of unions and families were rewarded with the introduction of Bill C-45, commonly known as the Westray Law. This bill was passed in 2004 and became Law C-21. It amended the Canadian Criminal Code to include specific provisions making corporations and their officers criminally liable for negligence resulting in workplace injury or death. C-21 is a historic step forward in protecting Canadian workers. For example, Section 217.1 of the Criminal Code, which was added by this law, states the following: everyone who undertakes, or has the authority, to direct how another person does work or performs a task is under a legal duty to take reasonable steps to prevent bodily harm to that person, or any other person, arising from that work or task. Employers are under considerable pressure to exercise due diligence to ensure the safety of their employees. An organization found guilty of criminal negligence can face severe penalties, ranging from financial sanctions to imprisonment for the responsible officers. One of the central concepts of C-21 is due diligence. In terms of occupational health and safety, this means that employers must not only identify hazards in the workplace, but also implement measures to prevent accidents and injuries. They must be proactive and integrate risk prevention into their daily practices. Employers must also fulfill 3 essential duties. Foresight, which enables us to anticipate workplace hazards. Efficiency, based on the concrete implementation of safety measures. And the duty of authority, by which they must demonstrate absolute intolerance for dangerous behavior. Finally, the tragic story of the Plymouth mine is a poignant reminder of the consequences of neglecting safety. However, the lessons learned from this event led to a major reform of the criminal code, making companies and their officers more accountable than ever before. Today, due diligence and prevention are fundamental in occupational health and safety risk management. Justice has not always been done for the victims of the past, but it now watches over the workers of the future.